going to start out tonight with a quote. This is from Thomas Jefferson, and he says, "An educated citizenry is a vital requisite for America's survival as free people." I love that quote. Came across it tonight when I was getting ready for class, and I thought this is what this class is all about. I'm a member of the National Constitution Center in Philadelphia, which really champions and endorses this kind of class all around the country. So, trying to get more and more people to understand the Constitution. And we say understanding the Constitution, it's really understanding America. It's really understanding how America works, because the Constitution, is America. So that's, I think, Thomas Jefferson would be smiling if he knew about the class here tonight. Thank you all again for coming out. The roadmap for tonight, is powers of the president. This is focused on the powers of the president. We're going to look at his powers, the limits of those powers, and we're also going to look at how the presidency starts, that is how you elect a president, and importantly, how the presidency ends, how you end a presidency. So we're going to look at the start, the middle, and the end of the presidency. And we're also going to look at some very famous cases today. We're going to look at Youngstown Steel, the Youngstown Steel case, which is one of the top 10 most important cases ever in constitutional law. We're going to look at the Nixon tapes case. We're going to look at two cases involving President Trump, and we're going to look at the Hamdi Guantanamo Bay case. Before we turn to those, one thing I always like to do in my class at Georgetown is pull out the newspaper, and I just was telling Roger that this is from yesterday's Washington Post, and I could not have been more excited. I opened the paper looking for some nice stories to talk about the Constitution, and this story is just like exactly the topic for our class today, which is Trump has made hundreds of sweeping promises for action on day one. Does he have the authority to carry out those promises? And the same thing could be said for Kamala. As Kamala Harris, does she have the power to carry out the things she's promising? So that's going to be exactly the topic for today. So, as I say, every day in the paper, there are stories about the Constitution. So today's class is about the powers of the president. The first class, we looked at the history of the Constitution, and we looked at the judiciary, including the founding case of Marbury v. Madison, which gave a lot of power to the courts, and that Marbury v. Madison decision has stood the test of time for 230 years. And the judiciary today, that branch of the government, which seems like the weakest branch, is very strong. Last week we looked at the powers of Congress. This week we're looking at the powers of the president. So we're going to cover all three branches. And then next week we pivot to individual rights, starting with equal protection, and then due process and free speech in the First Amendment. All of those are some of our core individual rights. So the class today is about the president, and you could also title the class today, instead of powers of the president, you might also title it, how does America avoid having a dictator? That could be the name of the class. How do we avoid having a dictator in America? The founders were very focused on that exact worry, on that danger. They knew that if they gave too much power to the president, there was a great risk of dictatorship, or if they allowed the president to take too much power, we could have a dictatorship. A dictator is not constrained by law or by the Constitution. A dictator does not respect individual rights, life, liberty, and property, which we so cherish in our Constitution and in the Declaration. A dictator throws his enemies in jail for any reason that he can conjure up or for no reason at all. Dictators tend to be cowards. They tend to be afraid of those who disagree with them, and they want to stop them from voicing the reasons for their disagreement because it might make the dictator look bad. Unfortunately, the world today is filled with dictators. President Putin in China, President Xi in China, President Putin in Russia, President Xi in China, and the leaders of North Korea, Syria, Belarus, and Venezuela, to name a few. There are different degrees of dictatorships, of course. Some of them have more individual rights or others, but all of them share common features of a dictatorship. The founders and the folks living in these countries don't have the freedoms that Americans very much take for granted. These are incredibly important freedoms we have. We're going to talk about those freedoms the next Class 4, Class 5, and Class 6. But I think one of the things that's kind of a shame in this country is we take those for granted. We don't realize how valuable those freedoms are. The founders did, and the founders recognized the dangers that we could lose those freedoms if the president became too powerful. And we know the founders were focused on these for a variety of reasons, the most important, the way they shaped the Constitution. But it's also worth quoting that critical document that the founders treated as a Bible, which would be the Declaration of Independence. And in the Declaration of Independence, two quotes I want to read that are relevant to today's class. The first says, "The history of," and this is a direct quote from the Declaration, "The history of the present King of Great Britain is a history of repeated injuries and usurpations, all having in direct object the establishment of an absolute tyranny over the states. To prove this, let facts be submitted to a candid world." And then, as we know, the Declaration goes into a list of 27 different sins or injuries that they attribute to the king, which was King George III. Then the Declaration has this quote, "In every stage of these oppressions, we the people have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. A prince whose character is thus marked by every act which may define a tyrant is unfit to be the ruler of a free people." So right there, of course, the founders were calling King George a tyrant, a dictator, and they did not want to repeat that. Now, so that was one set of forces that the founders had in mind when they drafted the Constitution in the summer of 1787 in Philadelphia. But the opposite force was, of course, the failure of the Articles of Confederation. We had our first Constitution, the Articles of Confederation, only lasted 4 or 5 years, and they gave almost no power to the president. There really wasn't an actual president under the Articles of Confederation, and the country suffered greatly from the lack of an executive authority. So these two competing forces, we don't want to have a tyrant, we don't want to have a king, we don't want to have a dictator, but we also need to give enough power to the president so he or she can get the job done. So that's kind of some background. Now let's look at the actual powers of the president. We looked at the powers from Congress last week, and one of the remarkable things of the Constitution, it sets out, it lists, it enumerates the powers of Congress. Article 1, Section 8 lists those powers. There are quite a few of them, but they are limited and defined, and Congress's power does not go beyond those enumerated powers. Similarly, the president's powers are laid out in the Constitution. And I like to think of them as 6 powers. The president has 6 powers, and really only these 6. And they are, number 1, the pardon power. He can pardon people. Number 2, the veto power. He can veto bills. Number 3, the appointments power. He can appoint ambassadors and justices of the Supreme Court and heads of departments. Number 4, the commander-in-chief power. He's a commander-in-chief of the armed forces. Number 5, foreign affairs power. He leads the country on foreign affairs. And 6th, and most important, he executes the laws. He is responsible for carrying out the laws passed by Congress. But those are the 6 powers, and those are it. And we're going to read, when we read the Youngstown case, we'll see how the court describes those powers. Interestingly, 4 of the 6 are shared powers with Congress. The president alone has the pardon power. That is his alone. And the power to execute laws, that's his power alone. But the other 4 are shared. The president can veto legislation, but Congress can override the veto, and they often do. The president is commander-in-chief, but as we saw last week, Congress has all kinds of war powers, right? They have the power to declare war. They have the power to set rules for the military. They have the power over the purse to decide how much money to give the military. So Congress has, the war power is a power that is very much shared. The question of war power is a very interesting one. I've done a lot of writing on the war power and teaching it, and you could really have an entire session just on the war power. But we'll say a few things about it now. because it's a very important power that is shared between Congress and the President. So the President is the Commander-in-Chief. Congress has the power to declare war. So we started out in our nation, in the early years, the early decades, it was clear that Congress and the President honored that. When we went to war in 1812, the War of 1812, or the Spanish-American War, or the Mexican-American War, or World War I, or World War II, Congress declared war. If there was going to be a declaration of war, Congress was going to declare war, and then the President could carry out the war. He would execute the war as the Commander-in-Chief. But if Congress didn't declare war, we wouldn't have the war. Things changed quite dramatically with the Korean War. That was the first war where the President took the military to the battlefield without a declaration of war from Congress. And that set a precedent that sadly has been followed in the last, since the Korean War, in the last 70 years. Now, sometimes Congress still declares war or gives authorizations to use military force, but sometimes they don't. Sometimes they abdicate that power. And so there's this battle between Congress and the President over war power. Sometimes when the President, many times when the President has used war power without authorization from Congress, a few congressmen have sued, have tried to stop him from using that war power. Most of the time, the Supreme Court or the courts will refuse to take those cases, considering them to be political battles between the two branches. It's generally accepted that the President can use military force in 3 situations. And then there's a fourth that's not accepted, but the presidents do it anyways. But the 3 that are accepted, when Congress authorizes the use of military force, and everybody agrees Congress doesn't have to, there's no magic words. They don't have to say, we declare war. They can say, we, Congress, authorize you to engage in military, take military action. So, for example, after 9/11, immediately after 9/11, Congress passed an authorization for the President to use military force against those who committed the 9/11 acts. So, and then again, when he went to war in Iraq the next year, Congress authorized military force in Iraq. But in many other situations, the President has used military force without our authorization. So what are the 3 situations where the President can use military force? Number one, where, the first and the best is where Congress has authorized it. That's easy. Number 2, it's widely recognized the President can use military force in self-defense. So if there's an attack, or if it appears likely there's going to be an attack on the U.S. or our interest around the world, the President can use. He does not need to wait for Congress. It's often said the Constitution is not a suicide pact, and that means that the President, if the opposing enemy is on our shores attacking us, he doesn't need to wait for Congress to give him authority. He can go defend us. And then the third one is this idea of kind of a limited use of the military in small ways that don't amount to war, and so it's felt that the President as Commander-in-Chief can move the troops around, can position ships to send strategic messages. Sometimes, for example, the President will send a battle group or a carrier group somewhere to send a message to a particular country. So those are accepted, but the real problem is the Korean War is the best example, because there's no doubt the Korean War, we were not repelling a sudden invasion, it was not a defensive war, and there was plenty of time to consult with Congress, and this wasn't a small little skirmish. The Korean War was a massive, full-out war. It was an absolute war. We didn't have authorization for it. So again, the war powers is an interesting area, shared between Congress and the President, but the President has taken more of the war power, and Congress has abdicated more of the war power. And a lot of people, when they talk about this, they like to quote Napoleon on this topic. And they say that, a quote from Napoleon is, "The tools belong to those who will use them." And the wisdom of that, and you may not like Napoleon, but it was a wise quote, because he's saying, look, the President he's got war power and he's using them. Congress just can't get their act together and decide what they want to do, so they're not using them, so they're abdicating to the President. A lot of congressmen today recognize this problem and they want to fix it, so maybe we'll see some improvement. But for now, it's kind of a question of Congress abdicating to the President. So that's kind of that's the commander-in-chief power. You know, we mentioned the veto power is shared. Foreign affairs power is shared with Congress. You know, Congress gets to approve treaties, and they get to approve the appointments of ambassadors. And of course, even in the foreign affairs realm, very important, Congress controls the purse strings. So they can really influence foreign affairs. So it's recognized that while the president is the leader and the spokesperson for America on the world stage, that foreign affairs power under the Constitution is shared. So the veto power is shared. The appointments power is shared, commander-in-chief power is shared, foreign affairs power is shared. And then that gets us to executing the laws, which is the biggest power of all. The president has, Congress passes laws, and the president has the power to carry those laws out. When the president carries those out, it's when he's executing the laws, he's carrying out the laws, he's executing the laws. He does that with a massive, massive apparatus of the federal government, right? So we have this absolutely massive federal government, Department of Education, Department of Defense, Department of State, the EPA, the FBI, the CIA, NASA, HUD, you name it, right? There are hundreds and hundreds. If you ever Google all the federal government agencies, just federal, not state, just federal, you know, there are many, many hundreds of them. And they all assist the president in carrying out his duty to execute the law. Now, of course, we're going to get to this more and more as we go through the class today, but what does it mean? So this is probably the president's single biggest power. So the Congress passes a Clean Water Act. Okay, and the Clean Water Act is maybe 100 pages long. It covers some issues, but there's many, many contingencies, many situations it does not cover. So the president, it's his job and the job of the agencies that work for him, in this case the EPA, to fill in that law with regulations. And that's where the president's power is so great, because he can influence. He says, okay, Congress, you said clean water, and you said 10 different points about the Clean Water Act, but you didn't resolve, you know, what about a stream that's not, you know, connected to a navigable waterway? Can we regulate, you know, the water in that stream? And so by interpreting statutes and by imposing, you know, by saying, hey, I'm the president, I'm going to carry out Congress's law, but it's not clear exactly what they wanted, so I'm going to carry it out in this way. We see that a lot in immigration. In the immigration context, Congress generally passes all the immigration laws. The president can't pass an immigration law. Only Congress can do that. But at this point, there are a dozen or more immigration laws on the books. They're out there, and the president has to carry out those laws. And he can say, well, I read this particular law, this section of this law this way. I believe this particular law gives me authority to carry out a deportation of these group of people. I'm going to deport this group of people. Those decisions, if the law supports him, then the president wins. If the law doesn't support him, the president loses. And that is one of the most common, you know, battles in court, when the president says to one of his Secretary of Education or the EPA, I want you to take this action to carry out the law. The question is the action the president's taking, is it consistent with the law passed by Congress or not? If it's not consistent, if it violates the law that passed by Congress, it'll be struck down. And we're going to see examples of that. So the key, of course, is that the president only has the powers given to him by the Constitution, those 6 powers. If the president or the agencies or departments acting on his behalf take action outside those powers, then that action is unconstitutional and can be struck down by the courts, which the courts have done literally thousands of times. So one interesting example, I Googled, just to take the last full 4-year presidency, was President Trump's 4-year presidency from 2016 to 2020. There were 246 cases where his regulations were challenged, where he asked one of his agencies or departments to execute the law. I want you to execute the law the following way. Of those 246, 192 were struck down as invalid, and 54 were upheld. So his win-loss ratio was less than 1 in 4. in other words, more than 3 in 4 of his efforts were struck down. So the lesson here is that every time you see a president act, you got to ask yourself, under what authority is he acting? He needs an authority either from the Constitution itself, which I mentioned there were 6 powers. Is it one of those other 5 powers, veto, appointment, foreign affairs, etc., or is it the 6th power? Is he executing a law from Congress? Most of the time when the president acts, he will actually do you the favor. He'll say, I'm acting. If you actually get the law and read it, or if you get the regulation that the president is issuing, or if sometimes it'll be an executive order. If you read the executive order, he'll say, pursuant to such and such law passed by Congress, I am issuing this executive order. So, that every time the president acts, you ask yourself, is his action lawful? And is it, by another way of saying it is, does his action come from the Constitution or come from a law passed by Congress? Okay, so that's a little bit of the background. It's you have the president. He's got these powers that are given to him right in the Constitution in Article 2. Article 1 is Congress. Article 2, President. Article 3, the judiciary. Or is he engaging in action that is authorized by Congress? And so that's the theory. Now we're going to look at 4 cases that kind of put this more into concrete practice with concrete facts. So the first case, Youngstown Sheet and Tube v. Sawyer. Again, this is probably one of the 10 most important cases in our nation's history, and it's a seminal case. It's been cited by the Supreme Court hundreds of times, and it was a 1950s case, but it is very much good law today. It was issued during the Korean War. So during the Korean War, steel workers had threatened to go on strike. They wanted higher wages. There was failed labor negotiations between the union and the management. Industry refused the demands of the workers, and so they went on strike. President Truman, on the eve of the strike, issued an executive order ordering the Secretary of Commerce to seize the steel mills and to ensure that steel production continued during the Korean War. President Truman argued that steel was essential to the war effort. A strike would create a national catastrophe, and that the strike posed a national emergency, and that President Truman had to act. If he didn't act, the Korean War effort would be greatly harmed. So that was his argument. He issued an executive order to seize the steel mills. You can find the executive order online. This is a small part of it. Right here, this is the actual executive order that he issued, but it says, I just quote it's actually a very long order, but to paraphrase the most juicy part, he says, the Secretary of Commerce is hereby authorized and directed to take possession of all or such of the plants, facilities, and other properties of the companies named in the list attached hereto. So basically, the steel companies. Youngstown Sheet and Tube, which, by the way, I've done a lot of work for this company over the years, and not in this area, but in other areas. But they're one of the great old steel companies from Youngstown, Ohio. They sued. They did not like the fact that their steel mills were seized. They said, wait a second, we don't want the government taking our steel plant. So the question was, did President Truman have the power to seize the steel mills? But first you have to appreciate what a great country we live in, right? Because in Russia, Putin's like, I don't care, I'm taking the mills, get the heck out of it, right? So in a lot of countries, we never even get to the point of a Supreme Court that could actually tell President Truman no, right? In a lot of countries, I'm going to take the steel mills, get out of my way. So in an opinion by Justice Hugo Black, the court said that the key question is, said that the president's power, this is a quote from the decision, the president's power, if any, to issue the executive order seizing the steel mills must stem from either from an act of Congress or from the Constitution itself. So that's one of the famous quotes in the opinion, and it's very clear, it's very simple. the president's action must either come from the Constitution itself, and when they say the Constitution itself, what do they mean? They mean those other powers, the veto power, the pardon power, the appointments power, the foreign affairs power. Now, President Truman tried to argue the foreign affairs power. He said, well, war is kind of like foreign affairs, or it involves other nations. So the court threw that out very quickly and said, this is a to allow you to do this. Look, the power to seize the steel mills does not arise under the specific grants in the Constitution. So then the only thing it could arise under would be a law of Congress. So then the court said, all right, well, are there any laws from Congress that authorize the seizure of plants or mills, perhaps during a labor strike? And the court said, well, in fact, Congress had considered this. There'd been a debate in Congress over whether to have a law that allowed the seizure of factories that were of national security interest if there was a strike during times of war. And Congress debated it and soundly rejected it. They soundly rejected that law. They said, we're not going to pass this. We think it's a bad law. We're not going to allow the seizure of plants in this country for any reason. So the court said, look, sorry, President Truman, we have the greatest respect for you as the president, but the power to seize the steel mills does not arise under the specific powers in the Constitution, and it doesn't arise under an act of Congress. And in fact, the Congress has actually said the opposite. You can't seize the steel mills. So therefore, the court struck down the executive order as unconstitutional. One more quote from the court. The court said, the founders of this nation entrusted the lawmaking power to Congress alone, both in good times and in bad times. It would do no good to recall the historical events, the fears of power, and the hopes for freedom that lay behind their choice. Such a review would but confirm our holding that the seizure order cannot stand. So I loved these they gave Congress and Congress alone the lawmaking power. President Truman could not make the law. Even if it was a wise law, even if it was a good law, he had no power to make law the way he was doing here. And the quote of the fears of power, that is the fear of dictatorship, the fear of the president becoming too powerful, going beyond his constitutional power, and therefore threatening our liberty. The decision is also famous for a concurrence, sometimes strange little bits of constitutional trivia, but the concurrence by Justice Jackson in the Youngstown case is equally famous. And in that concurrence, Justice Jackson first took on one of President Truman's other arguments. President Truman also argued that there were inherent emergency powers that a president had to have. There had to be emergency powers to act in times of emergency for the betterment of the country. Justice Jackson has a great quote that said that the founders knew what emergencies were, and then he said, the quote is, and they knew too that the power, that emergency power, if you have emergency power, that tends to kindle emergencies. I love that line. So if you have emergency power, then the president's going to, oh, here's an emergency. I guess I got an emergency here. And he said the founders debated this and unequivocally said there is no emergency power for the president. The president's powers are what are set forth in the Constitution, and that is it, nothing else. And those powers do not include emergency powers. Then Jackson set out his famous tripartite test, his three-way test for presidential power. And this is the test that everybody learns in law school. It's on a lot of law school exams, but it's the Jackson three-part test. And here's what it is. He says, the president has three levels. His power is weakest or middle or strongest. The president's power is strongest when he's acting pursuant to congressional authorization or a constitutional provision. So the president vetoes a law, that's the strong, no one can stop him from vetoing, that's in the Constitution. Now the middle zone is when the president acts absent clear congressional law, when the Congress is silent, they haven't said anything yes or no. Then he's kind of a middle zone, a twilight zone, maybe concurrent power with Congress. And then he's at his weakest when the president acts in a way that is inconsistent with a law passed by Congress and not supported by any other provision of the Constitution. And Jackson said that's what happened here. There's no other support in the Constitution, no independent support in the Constitution for seizing the steel mills, and in fact the seizure goes directly against the will of Congress. So that three-part structure, the strongest, the middle, and the weakest power of the president, is something that the court looks at all the time today. All right, next case. That's Youngstown Steel, an incredible, yes?
Just quickly, what was the ruling and was there any dissent? And if there was dissent, what was it?
There was a dissent, yep. There was a, and we'll definitely get more into this in the Q&A, but there was a dissent that said there had been a pattern and practice by prior presidents of these kinds of executive orders, and that pattern and practice established should be good enough for the President Truman to rely on. But the ruling was, couldn't seize the steel mills. That was it. Now, in fact, the strike ended very quickly, so it turned out to be kind of a moot point because the strike got over with. The management, the workers reached agreement, and they went back to when the steel mills opened back up. So it's kind of but it was just like Marbury v. Madison, right? This tiny little issue of whether Marbury gets his job created this incredibly important Marbury v. Madison case. This case, where President Truman thought he had this, if he just waited a couple days, the workers and the management would have got together and solved it. But instead, he just did this thing, and it gave the court this opportunity to say, absolutely not. So he was just unequivocally overruled by the court. All right, now we're going to jump forward 20 years to the Nixon tapes case. Some of you remember Watergate, no doubt. Some of you might be too young for Watergate, but when I talk to Watergate with my kids, they're like, "What's Watergate?" So, all right. June 1972, a break-in at the Democratic headquarters in the Watergate Hotel. I guess the Watergate, I don't know if it was a hotel back then, but the Watergate building. Very soon thereafter, the press and Washington Post started to dig into the story. At the time, they thought it was a relatively small story. They didn't know how far up the break-in went, how far up the government chain. Archibald Cox was appointed a special prosecutor to look into the Watergate scandal as the scandal got bigger. And that was in the summer and the fall of 73. And then October of 73, and remember the first year Watergate started out, hardly anybody knew anything, didn't think it was that big a deal. Nixon was reelected in a landslide, so he had a lot of power. Archibald Cox, a Harvard lawyer, started digging in, and he started to find more and more evidence pointing higher up the chain of command towards Richard Nixon and his senior staff. So Nixon didn't like the fact that Archibald Cox, the special prosecutor, was getting closer and closer, and so he, in October of 1973, a day called the Saturday Night Massacre, Nixon ordered his Attorney General, Elliot Richardson, to fire Archibald Cox. But Richardson refused, saying it was not right, and instead he resigned. Then Nixon ordered the second in command, William Ruckelshaus, to fire Archibald Cox. Ruckelshaus also told President Nixon it was improper to fire a special prosecutor, and also resigned. Finally, Nixon ordered another lower-level justice official, Robert Bork, to fire Archibald Cox, and Bork agreed to do so. Bork never escaped the shame and criticism for his act that followed him the rest of his life. March 1974, jump ahead a few months, a Watergate indictment is returned by a grand jury against 7 Watergate defendants, and Nixon is named as an unindicted co-conspirator. April 1974, the new special prosecutor, Leon Jaworski, subpoenaed a new set of presidential tapes that had come to light in the testimony. The President Nixon released edited versions of these tapes, but refused to release the tapes in full. On May 1st, the President moved to quash the subpoena of Leon Jaworski. May 20th, the federal district court denied President Nixon's request to quash the subpoena, and the case went to the Supreme Court. At the Supreme Court, Nixon refused to turn over his tapes and argued that he had an absolute privilege and that the court had no role here. That these were private conversations with the president and that the court had no real role here. And he supported that with a separation of powers argument. He said, if you if you, the court, if you, the judiciary, intrude into the private negotiations and discussions in the Oval Office of the President, you will weaken the President. And and anything that unduly weakens the President violates separation of powers. He also said, as a backup argument, he said, well, even if I don't have absolute privilege, I at least have a partial privilege here, and you should refuse to release these, refuse to allow these tapes to be released because they contained sensitive material, national security material, etc. The court, in a unanimous opinion, 8-0, one justice recused himself, but a unanimous decision rejected President Nixon's arguments. The court ruled that that it is not for the President to decide the court's jurisdiction. The court cited Marbury v. Madison and said it is the province and duty of the Judicial Department to decide what the law is, quoting Chief Justice Marshall from 200 years earlier. The court said, we do recognize a presidential privilege. We recognize the importance of the office, and we would not intrude on that lightly. If this were a civil case, or if this were a less important case, we would not intrude on that, because we do respect. The court went to some length. Really, it was a very, very polite opinion, very deferential to the President. It was kind of like, we're saying, we really respect you, but we're going to rule against you. So they said, look, in the right case, we might uphold your privilege. We recognize there is a presidential privilege against turning over presidential materials, but that privilege can be overcome if the need is great. And here the need was great because criminal prosecutions were ongoing, people could be thrown in jail, and the truth needed to come out. The truth had to come out so that people could have fair trials. So that decision by the Supreme Court came out in July, and at this point things were moving very fast. And you might remember the energy around this time. The case went to the Supreme Court in June. The decision came out July 25th. July 27th, the first article of impeachment was filed against Richard Nixon. August 6th, Nixon made the transcript of the tapes available to the public. The transcripts containing various smoking guns showing his deep involvement in the cover-up of the Watergate break-in. August 9th, 1974, Richard Nixon resigns. So that was, again, an effort by did the question of how much power does the President have? Does he have absolute immunity from this kind of a subpoena? The court said in a unanimous decision, no, he does not. Now, later on today, we'll get to the brand new immunity decision, and we can kind of compare and contrast the two. But I will say that the current immunity, the immunity decision that just came out a couple months ago, the court believes was fully consistent with the Nixon tapes ruling. Okay, now before we get to the immunity ruling, we're going to mention two other cases briefly. There are hundreds and hundreds of these presidential authority cases. And sometimes the president wins these, sometimes the president loses these. He certainly doesn't win them or lose them all. Sometimes he wins, sometimes he loses. But another important one, a very important one, was the Hamdi case. Hamdi was an incredibly important case and really an eye-opener for a lot of people. Hamdi was 2004, just a couple years, 3 years after 9/11. We all know how bad 9/11 was. Hamdi was a U.S. citizen caught fighting in Afghanistan alongside the Taliban. He was captured and detained as an enemy combatant, a prisoner of war. He was held in Guantanamo Bay, Cuba. He filed a habeas corpus petition saying his rights were being violated. He wasn't given any due process. He had no lawyer. He had no ability to talk to anybody. He didn't know what his charges were against him. President Bush said, as a citizen, this is the war, this is the Afghan war had been going on for a couple of years after 9/11. President Bush said, look, if you were as a regular citizen in jail, you'd have all the constitutional rights that are in the Bill of Rights. And the Bill of Rights, of course, gives many, many rights to criminal defendants. But you are an enemy combatant. You're a prisoner of war. You have no rights as an enemy combatant. So we're going to hold you indefinitely at Guantanamo Bay and not tell you what your charges are against you, not provide you hardly any information about your case, not give you a lawyer, etc. The case went to the Supreme Court. Hamdi obviously was a very unsympathetic. There was not a lot of sympathy for people like him soon after 9/11. People were, but the court said, you know, he's an American citizen, he's entitled to these due process rights, even though he was caught as an enemy combatant. The court ruled against President Bush on 4 of the 5 grounds. They said that Hamdi has a right to counsel, he has a right to confront witnesses against him, he has a right to hear the specific charges against him, and other rights contained in the Bill of Rights. So again, it was a victory for civil rights, for individual rights, a surprising ruling against President Bush at a time when again, there wasn't much sympathy for people like Hamdi. Next case, very quickly, Trump v. Vance. This is a 2020 case. You'll remember this. President Trump refused to turn over financial records that had been subpoenaed by the state prosecutor, Cyrus Vance. They were looking into some questions about financial crimes. President Trump, like President Nixon, claimed absolute immunity from the need to comply with the subpoena of his records, and Trump refused to turn them over. In a 7-2 ruling, the court ruled against President Trump in order that the president is not immune from criminal subpoenas, and while they would apply a balancing test, and under some circumstances they would respect the presidential privilege against subpoenas, here the needs of a criminal prosecution and the needs for the truth to come out for a fair criminal trial outweighed his concerns, and so they ruled 7-2 against him, and Trump was ordered to turn over the records. Interestingly, 2 justices appointed by Trump, Justice Kavanaugh and Justice Gorsuch, both ruled against President Trump in that case. And here is a quote from the opinion. This is from the Trump v. Vance opinion. 200 years ago, a great jurist, Chief Justice Marshall, established that no citizen, not even the president, is above the common duty to produce evidence when called upon in a criminal proceeding. We have reaffirmed that principle today and hold that the president is neither absolutely immune from state criminal subpoenas seeking his papers, nor entitled to a heightened standard of need to produce those papers. So that's that is the lead up. That's kind of the lead up to the immunity decision. So the immunity decision just came out a few months ago in July of this year. So it's very, very fresh. So I love the fact that in this class we're looking at cases as old as Marbury v. Madison and as new as just a few months ago. So we get to span the whole 230 years. So the background to the Trump immunity decision, we know that President Trump is facing criminal prosecution in 4 different cases, 2 state court cases in Georgia and New York, and 2 federal cases, one in Florida and one in D.C. And the one in D.C. is focused on his efforts to overturn the election results in 2020 and the events leading up to the January 6th attack on the Capitol. We also know that in New York he's also been found guilty already and is awaiting sentencing in the New York criminal trial. So the immunity case, and Trump asserted that he was absolutely immune from any criminal prosecution for any of his acts while he was the president. Now, take one step back. You may remember that Bill Clinton had been sued by Paula Jones for sexual assault charges. It was a civil case. She was seeking damages. It wasn't a criminal case, but it was a civil case. And that the alleged assault that Jones accused Clinton of occurred before Clinton was president, and the court, but the suit was brought while Clinton was president, and the court allowed that case to proceed because they said it's a civil case. There's no danger of interfering with the presidency. He's not going to go to jail. The worst that would happen is he has to pay a fine, and he can spend very little time. He can have his underlings and staff for most of the trial. So they felt that the demands on Clinton were very minimal, and and his needs could be accommodated. So they allowed that case to proceed. Trump said, here, this is a criminal case, far more disruptive of the president. There has to be absolute immunity for acts taken by the president, even though now he was a former president. He's a former president, but the question is, can a former president, so the precise question was, can a former president have a criminal case brought against him for acts carried out during the presidency? And President Trump articulated different positions at different times, but his most extreme position was absolute total immunity, that I have absolute immunity for any actions taken while I was president. Now we know, just one more piece of background to the case, we know that there's it's not a law, but there's a Department of Justice policy, a written down policy that says that you cannot criminally charge a president while he's in office. So that you might have to wait till he's out of office, or he can be impeached and then bring the criminal charges. But while the president is in office, the position of the Department of Justice is he cannot be criminally sued. So with that, the court, the ruling came out, it was kind of 5-1-3, 5 in the majority, 1 concurrence by Amy Coney Barrett, and then the 3 in the dissent. The dissent was very, very vigorous. And strongly attacked the majority opinion. Quite something to read the dissent, but the majority is interesting as well, and the concurrences, they're all fascinating reads. But the court, in a large measure, split the baby. It certainly did not agree with President Trump that he's absolutely immune, far from it, but they also did find a significant amount of immunity. The court created 3 buckets. They said, bucket 1, President Trump does have total immunity for a small category of cases where he's exercising his core constitutional power. They've described that as the pardon power, for example, his foreign affairs power to recognize foreign governments, and then when he gives direction to the Attorney General to carry out the duties of the president in terms of executing criminal law. They said in these core areas, the president is totally immune and cannot be prosecuted, period. That's one bucket. The bucket on the other end is no immunity whatsoever for private acts. So if the acts are private, and we're going to talk about what is a private versus official, but for private acts, he has no immunity. So he can be sued, he can be criminally sued for private acts. A former president can be criminally sued for private acts. What is a private act? That is the subject of Special Prosecutor Jack Smith's 160-page brief, which I have with me if you want to read it, but it's, I've read almost all of it, but in that 160 pages, Jack Smith argues that all of President Trump's activities in cajoling the state officials to change votes, or cajoling the Georgia Brad Raffensperger to find 11,000 votes, all of that was private. It was a private candidate with private lawyers trying to stay in office. He wasn't acting as the president, he was acting as a candidate. So there's a big question about what is private and what is official. So I mentioned the 2 buckets on the end. On one end, there's a small category of absolute immunity. On the other end is no immunity at all for private acts. And in the middle is a contingent immunity or potential immunity for all of his other official acts. So if these are official acts that don't fall within that core bucket, and this would be 99.9% of his acts would not fall in that core bucket. So 99.9% of his acts that are official would fall in this middle bucket. And there's an immunity, but it can be overcome if the prosecutor can show that prosecuting the president for that official act would not interfere with his executive function. So those are the 3 buckets, and that's the test. The court also said that if you are prosecuting the president for something for which he is not immune, you cannot use as evidence something for which he is immune. So you can't use an act that he is immune for something you can't use his conduct for an official act where he is immune if you're trying to prosecute him for something where he's not immune. Amy Coney Barrett, in her concurrence, disagreed with that last point in particular. So these are, and the court said, you know, I think there were 2 main motivations for the majority. They had, number 1, they said if the president is under undue threat of criminal prosecution, if he thinks he's going to be prosecuted, he's constantly thinking about, okay, I'm the president, I'm taking this action, will this cause me to be prosecuted after I'm no longer the president? That might weaken the president or cause him to be less robust or less energetic or more unduly cautious, and that could harm the country. So the court articulated that fear, and said that that's a major motivation for finding some immunity. The court also said, believed, and this is more of a, we surmise this, but the court didn't really say this, but we believe that they felt that it would be very bad for the country and would look ugly if we fell into a pattern or a habit of the new president prosecuting the former president. And I think they had in mind not only the prosecutions of President Trump by President Biden, but the fear that President Trump, if he were reelected, could prosecute President Biden. And they said that turns the country into a banana republic. It's something we don't want. We cannot have that. So those are the motivations. I will hasten to add that we'll take about 2 more minutes on this, and then we'll stop for a break. The decision has been heavily criticized, and I tend to be a big fan of the Supreme Court. I tend to support, I think a lot of their decisions are right. I think this one has some major flaws. This probably drawn more criticism from constitutional professors than almost any other ruling. I mean, this has really come under fire by a lot of people who study this area. Not because everybody agrees, look, there's some areas that are immune and there's some areas that are not immune. That part we all agree on. But they felt that middle category, they gave far too much deference to the president, and they set a test that was far too hard to achieve to allow prosecution. I think another takeaway of this case, though, is the wiggle room. Major wiggle room in that middle category of, what can you show that if we prosecute him? So you can imagine what Jack Smith says is, look, yeah, maybe it was official. When President Bush was talking to when President Trump was talking to Vice President Pence around January 6th and urging him to reject the votes of certain states, maybe that was, I don't think that was official, but even if it was official, by prosecuting President Trump for that action, we can show that that's not going to interfere with any duty of the president, because the president has no role in counting the electoral votes. The vice president has a role. The Constitution gives the vice president a role, but the Constitution gives no role to the president. So even if we prosecute him for that, even if that's an official act, it's not going to interfere with the presidency. So I think a lot of people feel there's a lot of wiggle room in these tests. So hopefully in future cases, the courts will do the right thing, and where the president truly has engaged in a criminal act, the courts will allow the prosecution to go forward. And last thought before we take a break, we're going to find out really quickly, right? Because Jack Smith's brief, 160 pages, arguing he's got 50 different acts that he's arguing are private acts, or even if they are official acts, we can overcome the burden and we can say that we're allowed to prosecute. So we're going to get rulings pretty quickly from the district court, and then the Court of Appeal, and then the Supreme Court. So we're going to have an answer to these questions within the year. So with that, we'll take a break, 10 minutes, and then we'll come back and wrap up. Thank you. All right, we're going to go ahead and try to get rolling. Okay, so for the last 20 minutes or so, we're going to look at how the presidency starts, electing the president, and how the presidency ends, how you get the president out of office. Before we do that, I wanted to mention one more very recent case, and that, if you may have heard of the case that overturned the Chevron doctrine. And that came out just a few months ago as well. And it's important why do I mention it for this class? Because it goes directly to the power of the presidency. The Chevron decision, or the Chevron doctrine, which has been around for quite a long time, 40 years, said that when courts are hearing a challenge to a department, an executive department, or an administrative agency's regulations, they will defer to the expertise of that agency or that department. And by that deference, by saying we're going to give deference to the interpretation by the EPA or by the other Department of Education or what have you, that gave more power to the presidency, because he could, remember, the president, the Congress writes the laws, the president then carries out those laws by hundreds and thousands of little regulations that implement the laws. And the courts had, the Chevron doctrine was a doctrine that said, we will, as long as the agency's regulation is reasonable, we're going to defer to that, because they might know more about their specific area of expertise. Well, the court a few months ago rejected that and overturned the Chevron doctrine, saying that it violates the basic constitutional structure. There should be no deference. The courts are well equipped to decide on any given case whether a regulation by the executive branch complies with the law that it's implementing or not. And the court said, we're going to take back that power. And so by taking back that power, this ruling very much has the effect of reducing the power of the presidency. Okay, so with that, we're going to turn now to how the presidency starts and then how the presidency ends. And by the start, I mean electing the president. How is the president elected? Very timely. We've got an election in less than a month. Here are the constitutional provisions. So I'm looking at Article 2, Section 1 of the Constitution, the second paragraph. And it says that each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the number of senators and representatives. So that the states shall appoint the electors. The state legislature shall appoint the electors. And then drop down the next paragraph. It talks about how the electors shall meet and vote. And that paragraph was then amended by the 12th Amendment. A little tiny bit of history. Remember in 1800, the election between Thomas Jefferson, Aaron Burr, they tied. There had to be 35 votes. Finally, Alexander Hamilton threw his weight behind Jefferson, all very ironic because we know what happened with Hamilton and Burr, but Jefferson won. But the confusion arising out of the 1800 election led to the 12th Amendment, and the 12th Amendment guides the electoral process today. So again, the 12th Amendment is an amendment to Article 2, an amendment to how the electoral process works. We're going to talk more about that in a second. But then dropping down one more part, I'm still in Article 2, Section 1, dropping down to the next paragraph, it says, the Congress may determine the time and choosing the electors and the day on which the electors shall give their votes, which day shall be the same throughout the United States. So again, this is just what the Constitution is constantly doing this, giving some power to the states, some power to the federal government. This is the vertical balance of power. This is federalism, right? This was no mistake. This was very intentional by the Founding Fathers. We're going to let the state legislatures choose the electors. And then we're going to let Congress have a role also in setting the time and place for the electors to meet. And then so then let's come back to Article 2, Section 1. It sets up the Electoral College, and as I said, it was amended by the 12th Amendment. The Electoral College and the 12th Amendment, as the 12th Amendment lays out the Electoral College system, and I will paraphrase the 12th Amendment, but basically the 12th Amendment says whoever gets the majority of all electoral votes is the president. Currently there are 538 electoral votes, so you need to get 270 is the magic number. You need to get 270 electoral votes. If no one gets that majority, that 270 number, then the vote goes to the House of Representatives, and the House of Representatives votes for the president, but they vote with each state having one vote. Under the electoral voting system, a person can win the presidency, they can win the electoral vote and lose the popular vote. And that's happened, as we know, several times, most recently in 2016 when Hillary Clinton had several million votes more than President Trump. So many people ask, why do we have this crazy electoral college system? And there, again, this could be a whole nother night just on the electoral college system. And there are so many articles written on the electoral college system. And it's you know, some people think it is wise. The founders thought it was wise. They very intentionally gave us the electoral college system. Other people think it is anachronistic. Its time has passed, and we should move more to a direct popular vote for the president. So the founders had kind of two motivations when they put in place the electoral college system. One was kind of a fear of populism. They were afraid of the popular vote, afraid of populist movements, and they said it's better to choose the president by letting a set of wise people choose the president. Back then, wise men. They said, and these will be the state legislatures. They can choose the electors, and then the electors will choose the president. So that part of the Constitution has not changed. And so one amazing fact that people kind of blew my mind when I first discovered it was even today, tomorrow, all 50 states, because our Virginia could say, sorry Virginians, you're no longer going to vote for president. We've decided that the Virginia legislature, are going to choose the electors, and they're going to vote for president, and you're out of luck. We're not going to have a popular vote. Fortunately, that's highly unlikely to happen. That would probably cause some serious riots. And all 50 states have a popular vote for the electors. And the electors generally are required by the states to vote to follow the popular vote. So if Michigan votes for Kamala Harris, if she only gets 51% of the vote, or she gets 50.1% of the vote, she gets 100% of the electoral votes for Michigan. If Donald Trump wins Pennsylvania, same thing. Two states have a proportionate system, Nebraska and Maine, but generally that's how the electoral college system works. The winner of the popular vote takes all of the votes. So I mentioned that was one motivation, was the founders were afraid of kind of a populism, but that has gone by the wayside because the states, instead of choosing the president, having the legislatures choose the president, they have given it over to the people to have a popular vote. And so it's much, much more democratic than it was back then. Now you could say, maybe were the founders wise or not? Maybe is it smart to have the people choose the president? We think it is. We have a deep faith in democracy, but democracy doesn't always give you the result you want. The second motivation for the Electoral College was a very different motivation, having to do with the power of individual states. In particular, to get the Constitution ratified, the small states demanded that they be given power equal to the large states, at least in part. They knew that they were not going to have the tiny state of Rhode Island was not going to have the power of Virginia. So in the Congress, in the Electoral College system, California has a lot more electoral votes than Rhode Island. But still, the electoral votes are not handed out purely proportionally. If they were handed out purely proportionate, that is, if the electoral votes were purely proportionate to your population, California would have far more votes than Rhode Island. But every state is guaranteed at least 3 because you get at least the 2 senators and the 1 representative. So the Electoral College, by design, gives more power to the small states. So one final point about the Electoral College system, and this goes to January 6th and the attack on the Capitol. One thing that happened on January 6th was that President Trump urged Vice President Pence, strongly urged him, to say, look, use your power. The Vice President has a role in opening the votes. They literally deliver the votes to the Capitol, and the Vice President opens those votes, and then that's set out in the 12th Amendment. And the President Trump said, we want you, Mike, you need to kind of declare that the votes from Georgia and Arizona and Nevada are fraudulent. You need to throw them aside and let the House of Representatives decide, or at least send it back to those states. Fortunately for all of us, and I must say I truly admire Mike Pence for this, but he said no, that the Vice President does not have that power. But President Trump and his advisors said, Mike Pence, yes, you do have that power. You could do that. Second, on January 6th, in order to challenge the votes of any state, all you needed was 1 senator and 1 representative. That's all you needed. If you had 1 senator and 1 representative saying that we challenge the votes of Georgia, then the votes are challenged and it goes to a debate in Congress over whether those votes are valid or not. So people realized that that was a real problem, and the January 6th really shined a bright light on the problems of this, of the electoral vote count. And so they passed, in 2022, just 2 years ago, they passed the Electoral Vote Count Reform Act. And this thing did several things that were very important and very helpful. First, it makes clear that the Vice President has no role on the counting of the votes, other than purely their ministerial. The law says, quote, that the counting of the votes by the Vice President is, quote, solely ministerial, with no power to determine, accept, reject, or otherwise adjudicate or resolve disputes over the proper list of electors, the validity of the electors, or the votes of the electors. So making it very clear that the Vice President does not have that power. This is in the law passed 2 years ago. The old law, the old Electoral Count Act, had been passed in like 1876. So it was high time for a reform of the law. 150 years had passed. The second thing this law did, I mentioned before, you only need one senator and one congressman to challenge the law. Now you need 20% of each body to challenge the vote of a given state. So you need 20% of the senators and 20% of the representatives to even begin the debate on whether a vote of a particular state is valid or not. So making it much harder, raising the bar significantly to any challenges. Okay, so that's a little bit on the Electoral Count, Electoral College, and the Electoral Count Act. Again, the fascinating thing, what the Constitution very intentionally did was with an eye toward federalism, give the power to the states to pick the electors, and what that means now is the states set the rules even for presidential elections, not just for local elections, but the states set the rules for the presidential election. And then the Congress also has a role. They can set the times and dates for the electors to gather. But that's why, if you're wondering why, we have this, even for a presidential election, we have this patchwork. The polls in Virginia close at 7, but the polls in Maryland close at 8, something like that. Or, Maryland has one rule for mail-in voting and Virginia has another rule. Well, that was very much the design, was we want to give this power to the states to have a role in the presidential election. Okay, final topic for today, how do we end the presidency? If you have a bad president, how do you get rid of the bad president? So there are 4 ways at least in the Constitution to end the presidency. So to set the context a little bit, we know that dictators often don't want to leave power, right? So President Putin is on his 5th term as president in Russia. Fidel Castro served for 52 years as the head of the Cuban government. Saddam Hussein served as the president of Iraq for 24 years. President Xi in China is now on his 3rd term, et cetera, et cetera. People don't want to they don't want to give up power. So people don't think about this, but it's incredibly important to be sure that we can kick the president out if we don't like him, or if he's a bad actor. So the first way the Constitution does this is term limits. George Washington set the precedent by leaving office after 2 terms, voluntarily leaving the office after 2 terms, and thanks to George Washington for doing that. FDR, Franklin Roosevelt, broke that tradition by serving for 4 terms. After Roosevelt broke that tradition, what happened? The 22nd Amendment, an amendment that's not talked about very much, but a very, very important amendment. Very important amendment. The 22nd Amendment establishes a maximum of 2 terms in office. This is a hugely important safeguard against dictatorship. Hugely important. Nobody thinks much about the 22nd Amendment, but it is very important. When President Putin of Russia was up against term limits, he was going to be removed from office because of term limits. What did he do? He changed the law. He said, that law, we're going to change that term. I don't like that term law, we're going to change it. When President Xi, just recently of China, he had served his 2 terms, that is a 2-term limit in China. He didn't want to leave power. What did he do? He had his folks change the law, and they got rid of the 2-term limit. In America, we cannot do that because this is not just an ordinary law, this is the constitutional amendment, it's the 22nd Amendment. And we know how hard it is to change the Constitution, incredibly hard. So there's no prospect that the 22nd Amendment would change. Therefore, that 2-term limit is an incredible safeguard against dictatorship. Second way that presidents leave office, impeachment. The Constitution is quite focused on impeachment. Article 2, Section 4 of the Constitution, Article 2, Section 4, the President, the Vice President, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. Article 1, Section 2 says that the House of Representatives shall have the sole power of impeachment. So the House impeaches. And then Article 1, Section 3 says that the Senate shall have the sole power to try impeachments. And then you need 2/3 of the Senate to remove somebody, find them guilty and remove them from office. There have been 4 impeachments in our history. There would have been a 5th if President Nixon had not resigned. But there have been 4 impeachments. President Johnson, President Clinton, and twice for President Trump. No president has been removed from office, although most historians believe that Richard Nixon would have been impeached and removed from office had he not resigned. Okay, the third way to end the presidency, the people can vote the president out of office after 4 years. Don't think about it, people don't really think about it this way as a way to remove a president, but it's an incredibly powerful way to remove the president. The people vote the president out of office after just 1 term. This is a great example of the power of the people, or to state the same thing another way, a great example of the power of democracy. Of course, the people are the demos in democracy. This happened to Donald Trump in 2020. It happened to Jimmy Carter in 1980. It happened to our second president, John Adams. It happened to Herbert Hoover. It happened to the first President Bush. It's happened to many presidents. They wanted to stay. They wanted a second term, but the people said, no, we don't like you. You're out of here. So that's the third way we get rid of the president. And the fourth way is the 25th Amendment. The 25th Amendment deals with incapacitation of the president. We know, for example, Woodrow Wilson, President Wilson, had a stroke during his presidency and was not really able to carry on his duties as the president. Some people say his wife was kind of the quasi-president for quite a while. Franklin Roosevelt was disabled at different times. Different presidents have been disabled. When President Biden, in I think November of 2021, had a colonoscopy procedure, he used the 25th Amendment, and for about 2 hours, Kamala Harris was the acting president. People don't realize, so she's already had 2 hours of experience as the acting president under the 25th Amendment. But the 25th Amendment is another way it can be invoked if the president is disabled. Again, typically stroke, heart attack, something that they're truly unable to carry on. And there's a elaborate procedure in the 25th Amendment it actually sets up a process. If the vice president and a majority of the heads of the departments declare that the president is incapacitated, if he says, yeah, you're right, then that's it, the vice president takes over. But if the president and the vice president disagree, if the vice president says, the president's incapacitated, but the president says, no, I'm not, I'm fine, I can still be president, then there's a process to resolve the dispute. So then those are the 4 ways of the Constitution. So people don't think about it this way, but the Constitution creates quite a few ways to make sure we can get rid of the president, or stated another way, to make sure we can get rid of somebody who we fear may become a dictator or may have those tendencies. But there's also another way. This is where I'll close on this final thought. There's another way that we control the president, and that we can check and balance the president and even remove him from office. And that is the First Amendment. And the First Amendment is going to be the topic of our Class 6 today, Class 6, which will be in 3 weeks. But the First Amendment does a lot of things: freedom of religion, freedom to assemble, but most importantly, it gives freedom of speech and freedom of the press. Dictators fear free speech. Dictators fear a free press. They suppress any criticism of the government, and they throw their critics in jail. Just look at Russia or China today. They do this because they're afraid that free speech and free press will shine a bright light on their failures and their corrupt practices, and it may cause them to lose power. President Nixon felt the power of free speech firsthand. If you read the book, All the President's Men, which I highly recommend, or see the movie, All the President's Men, you see the power of the press very clearly in helping to drive President Nixon from power. That power is an awesome power that we have today, and that we use all the time to bring to light problems with the government or problems with the president. And again, we're going to take a lot closer look at freedom of press, freedom of speech in Class 6. But it's safe to say that, you look at one thing, my class at Georgetown, all my students are from all around the world. I teach LLM students they already have a law degree from their home country, and then they come to Georgetown to get an advanced law degree. And so we tend to talk a lot about what are the freedom of speech protections that they enjoy in their home country. One of the interesting things is that in the last 15 years, I've had an increasing number of students from China. And they're all great students. I love them all. They all tend to be very good students. But when we talk about freedom of speech, it's very interesting because they don't have a lot of freedom of speech in China. And so they're kind of amazed at the freedom of speech we have. I mean, one thing that's clear is that, and we'll talk more about this in Class 6, but it's safe to say that thanks to our Constitution, America has among the strongest protections of free speech and free press on any nation on earth. And that free speech serves an incredibly important check and balance on our presidents, along with the other checks and balances we've covered today. And with that, I'm happy to take any questions. I think back there, this gentleman had his hand up the longest, I believe.
Yeah, just for example, say we had a president in office that had sway over Congress, that also had sway over the Justice Department, who decided not to accept a ruling by the Supreme Court. What would the enforcement arm of the Supreme Court have at that time?
None, really. I mean, they have basically moral authority. I mean, that's one of the amazing things. I mean, by and large, in our 230-year history, presidents have obeyed the Supreme Court. I mean, President Truman didn't like that ruling, but he obeyed it. And there are hundreds of examples of presidents being ordered by the court to do things they don't like, but they've obeyed it. That is rule of law, and then rule of law is critical to freedom, to liberty, to our country. But if that ever happened, there's not a lot, countries can fall, countries can fail, and that would be one way that democracy could fail. So, yep.
What are your thoughts on the constitutionality of presidential signing?
I'm glad you asked that. So executive orders, they go by different names, but President Trump has talked about he was going to do a whole bunch of things on day one, signed a bunch of executive orders, proclamations, they have different names. But the key thing about executive orders is in a way, they're kind of nothing. And by that I mean, it's a way for the president to have drama and to have the cameras and say, look, I'm going to sign this piece of paper. But it's the president's job. President's job one is to execute the laws. And once Congress passes the Clean Water Act, the president can then call up the EPA and say, okay, let's have a meeting and let's talk about how we're going to execute the Clean Water Act. Or he can call the cameras in and say, all right, I'm going to sign this executive order telling the EPA how to carry out the Clean Water Act. It's really, the executive orders are just one way the president can do his job of executing the law.
So the presidential signings are the same thing as executive orders?
Yeah, I mean, executive orders is the most common name, proclamations, I mean, they go by a lot of names. They have legal effect, but they are weak. And they're weak for two reasons. First, because all they're doing is in every case they're the president carrying out what he thinks is either enforcing the law or enforcing his powers under the Constitution. But if he's simply carrying, 99% of the time, an executive order is simply going to be an order where the president thinks he's carrying out a law of Congress. So because of that, Congress can overrule an executive order by changing the law. Congress can say, okay, your executive order makes no sense, we're going to pass a new law overriding it. Or the court can override the executive order. And new presidents can come in and undo old executive orders. So executive orders are fairly weak, but they get a lot of attention. Presidents like them because it's a lot of cameras and lights and hoopla. Yes, I think actually he had his hand up first.
You started the class by saying this case stood the test of time. Does longevity give a case special standing?
That's a great question. Yes and no. So there's a concept called stare decisis, which is a key concept in the law, that the decision stands, a ruling stands, and we respect precedent. So in this country, we have the English law tradition, there's the civil law tradition, the English law tradition, and the civil law tradition is in France, and it's in the state of Louisiana, where my wife is from, and a lot of other countries. And there it's very much based on the codes, long written codes. But in English law, the English law tradition relies on precedent. One case builds on the next case, builds on the next case. And so the courts very much will say we respect precedent and we will follow precedent most of the time unless, and there's a test for overturning precedent. It's a test that shows, if the old decision can be shown to be clearly wrong, if there's not been reliance on it, they have this test. And when they overturned the Chevron doctrine, that had been a 40-year decision and they overturned it. They went through the process of saying, are we allowed under stare decisis to overturn this? And they kind of went through that. Of course, we're going to talk 2 weeks from now, we're going to talk about Roe v. Wade and the Dobbs decision. That's the class number 5. And that was, of course, overturning a 50-year-old precedent. But sometimes, of course, we're very happy. Next week, one of my favorite classes is next week, because next week we're going to talk about maybe the most famous case of all time, which is Brown v. Board overturning Plessy. And so sometimes you very much want them to overturn precedent. Of course, Dred Scott, another horrible case, was overturned by the Civil War, effectively. Yes, here.
I wish I could agree with you with all your optimism about the Constitution, and obviously you're giving us examples of it. I do not feel comfortable with what's going to happen with this election because there's been a lot of effort already across the country in various states to undo what I think would be everything on the table type of outcome. So, given that the states, there's clearly some specific states where I think there's efforts already underway to undo whatever the electorate may be saying in their votes.
Yeah.
So I'm really concerned about that.
So if everybody heard the question, the question is, in 2020 there were challenges to the vote count, but the courts rejected those, and we got the result that we think was the proper result. The question is, in 2024, will it be different? Will it be the same? Suggestion that maybe there's more planning this time by people trying to subvert the true vote. And obviously it can happen. I mean, the example of Venezuela is, to me, a shocking example. If you followed the election in Venezuela just this summer, President Nicolas Maduro, again, a dictator, clearly lost the vote by all accounts, everything I've read. He clearly lost the vote to his opponent, and yet today he remains in power because he refused to accept the outcome of that election. It could happen here. I mean, I can't guarantee. I mean, I'm very optimistic about our country, about our checks and balances, but it's not perfect. And that's why we have this class. That's why we're constantly out there struggling to educate people about our system and what people need to be involved. They need to vote. They need to watch. But remember, the courts are there too. President Trump, alleged in 2020 fraud across 7 states. Just happened, and that in a small way, that's what I like to think this class is doing. So, yeah, over here, Steve.
Going back to the execution powers, the signings of documents, what is there any checks and balances about the president dismantling government agencies so they can't execute the law?
Yeah, he's free to. So the question was, can the president kind of dismantle government agencies or change the structure? In most cases, yes. In most, like the Department of, especially the core departments, Department of Education, Department of Commerce, Department of Treasury, yeah, he can restructure those. He's free to do that. His job is to execute the laws, and if he thinks it's better to have, this structure rather than that structure, that's fine. There's a whole world of independent agencies. So the Federal Trade Commission, for example, which looks out for consumer protection and tries to fight antitrust issues, they are independent, and so that could be a whole nother class in a whole other night. But independent agencies have some protection from presidential meddling. But most agencies are not independent. Most are under the president, and he's free to alter their structure. But if he's, not executing the law, that can be the basis for a lawsuit, and that's often the basis for a lawsuit, especially in the environmental area. The Congress will pass an environmental law. There have been quite a few environmental laws passed. Congress will pass an environmental law. The president's failure to execute can and has been the source of lawsuits. People saying, you're simply not doing your job. We're suing to make you enforce the law.
Didn't Nixon try to do that? Not execute some stuff. Said, I don't agree with this. I'm not going to do it. You got challenged.
Yeah, certainly on environmental areas in particular, I think that was a ripe area for challenge against President Nixon, who refused to fit. But that's a common. So most lawsuits against the president are saying. The typical lawsuit says that the president's action, and again, the action is often carried out either through an executive order or it's carried out just through an action by an agency or by a department. Most of the time they're saying that action violates the law or it's inconsistent with the law. But sometimes they say the president's inaction violates the law. So yeah, back here I think.
So there's going to be a lot of ifs with this. Jack Smith's recent ruling, going against the ruling, is probably not going to take place before the election. If Trump wins, can he negate that, him even bringing that up? If he can't do that and it's brought up and Jack Smith says, yeah, the Supreme Court says, okay, you are not immune, will that have to go forward?
Yeah, so I think the first part is, I think everybody heard the question.
Trump just basically say whitewash everything away.
Right. I think the sad truth is that if President Trump does win the election, he can stop the federal prosecutions. He cannot stop the state prosecutions. So the Georgia prosecution would go forward, the New York sentencing would go forward. So he has no power to stop the state procedures, but he does have the power, very likely, to stop. Now, if he does, there might be some resignations, just like Elliot Richardson resigned when when President Nixon told him to fire Archibald Cox. You might have a lot of resignations, people disgusted, but he could stop those. Now, if he does not win, and then these will definitely go forward, and these will go forward fairly rapidly. I mean, if Kamala Harris wins, these will go forward fairly rapidly. My prediction is that Jack Smith will win. There are 50 different allegations. He won't win all 50. He might lose. The court might say, all right, these 10 are immune, but these 40 are not, or these 20 are immune, but these 30 are not. Yeah, so he's not going to lose. He's not going to lose them all. There are going to be quite a number that he wins on that they'll be allowed to go forward. Now, of course, all that means is that he can then go forward with the prosecution. Like any criminal prosecution, he then needs to convince a jury that President Trump is guilty beyond a reasonable doubt, right? Any criminal defendant has all of the protections of the Constitution. So this wouldn't be a final victory by the Justice Department, but it would be, I think it's highly likely that if the Jack Smith case goes forward, he will win on at least some of the 50 counts and that they will be found not to be immune. I think over here this person had a question.
What would be the downside if all the states decided to proportion their electoral votes instead of a winner-take-all system?
No downside at all, and many people think that would be a very good idea. There's no obstacle to that whatsoever. So, right now we have 2 states, Nebraska and Maine, but every state.
Why is it that so many do the winner, just because it's easy, or?
Politics, really. It just gives more, if you're, and I'm sure you've all seen the story of the great pressure in Nebraska to change. They have one district in Nebraska. Nebraska has proportionate electoral votes, and in one of those districts, the Democrat is likely to win Kamala Harris, and there's strong pressure to move Nebraska back to a winner-take-all. Because, again, if let's say President Trump wins Nebraska by 51%, he gets 100% of the electoral votes if it's winner-take-all. But there's absolutely no constitutional barrier. The states could change that for the next election if they wanted to. Yes, back here.
Since you talk with a lot of students from other countries, I wonder if you discuss the differences between the presidential system and the parliamentary and prime minister system in other countries, and what some of the interesting differences are, and specifically, what you think, if you were appointed to the Constitutional Convention of a new country, what you would suggest they do, something more presidential or something more like a prime minister or parliamentary system?
Yeah, so the question of, our current system, the presidential system, versus what they have in France, for example, something like that, a parliamentary system with prime minister and president. I mean, the benefit of that other system is that the power is even more distributed. There's probably less risk of a dictatorship there. I mean, it's amazing. Our country, we probably have a stronger president, more robust. He can act more quickly, more power aggregated into one person, the president, often described as the most powerful person in the world. And maybe it's too much power. So that's the debate we've had in class, is it too much power or not? Is it better to diffuse the power? I mean, so far in our nation's history, knock on wood, we've been successful and not had a president slide into dictatorship. I've tried to show you in the class today the tremendous number of checks and balances that stop the president from moving to a dictatorship. But if there's all these checks and balances could fail, and we could be in deep trouble. And I think the parliamentary system is probably safer in that regard. But of course, if you're going to have a dictator, they don't. Once you have that dictatorship, China, for example, they have he has absolute power, even though in theory they have a big legislative body that's supposed to pass laws. They don't seem to have much independent power. So sometimes what's on paper doesn't matter very much once the autocrat gains power. Yes, over here.
In the context of a would-be dictator, does the Constitution speak to anything that keeps the military in check?
No, I mean it's a great question. I mean the war power, the military, is divided between Congress and the president. Like I said, I mean very, very intentionally, the founding fathers gave the war power both to Congress and to the. So that's a check. I mean the president, Congress can pass rules about what the military can do, but the great fear is that the president could use the military to take power. It's never happened, but we've seen it happen in other countries repeatedly, and it's hard to think it could happen here, but it could happen here. So then another check, we haven't mentioned this yet, but another check. I mean, there are a lot of checks from the president. Another major check is, would people obey the president? I mean, you'd like to think that a president, if the current president or the next president calls up the military and says, look, I lost the election, but I want to stay in power. I'm ordering you to kind of, martial law, take over the streets. Hopefully, the general would say thanks, but no thanks. We're not following that order. Because the generals, they have their oath of office to the Constitution, not to the president. Back here, yeah.
Thanks. You couple of words for me that on this. In the Trump immunity case, the Court of Appeals was unanimous that he was not immune. It's like a 46-page decision, strong word. These are learned justices, 20-year veterans, whatever. Step below the Supreme Court, if you will. Why I guess in your opinion on how is that considered or not considered, or why the difference when they have the Supreme Court, if the Court of Appeals got it wrong, they unanimous, got all the way to appeals, still unanimous against Trump. And then the Supreme Court kind of muddled through kind of a mean kind of.
Yeah, and I one of the authors of that DC Court of Appeal is Greg Katsas, who is a law school classmate of mine, so I know him. And I thought it was a very good opinion. But I mean, the answer is that the Supreme Court really, they have a big ego. They have very big egos, and they're like, look, we're going to decide this question. We don't much care what the Court of Appeals has done. I mean, they they're going to look at it, they'll read it, but this is such an important issue, they were going to start from scratch and really, one of the things about the immunity decision, it was remarkable, if you listen, I listened to the oral argument as well, I mean, there was really a sense of history here, right? That this was the first case that the earlier, like the Nixon case had to do with whether Nixon had immunity from the obligation to produce evidence. That's very different from, do you have immunity from yourself being prosecuted? So the courts had a real sense of history here when they were hearing this oral argument in the Trump immunity case, and I think they said, look, we're gonna decide this, we don't really care much what the lower courts have done. So that's often the case. I think in less important cases, they might give more deference to the lower court, but in these big cases, they tend to really not give much weight to what the lower courts have said. Any final question back here?
You said, going back to the gentleman's question about the military supporting the president. But we saw yesterday, I think it was Article 1, that Congress has the right to call up the militia in the case of an insurrection. And then you also mentioned about all of the officers taking an oath to the Constitution to obey and defend it, and all enlisted take their oath to obey the lawful orders of the officers appointed over. So it's all tied back to the Constitution, which then gives us that. Isn't that the check?
Yeah.
That Congress says no.
Right, but then if as we've seen across the world, I mean, if once that is that and many other checks, I mean, but if the military decides to side with the president, who's going to stop them, right? Then your Constitution ain't worth the paper it's written on at some point. So that's why it's remarkable to me that this country for 235 years, we've had this Constitution, it's stayed in place, it hasn't changed, we have rule of law, we have our freedoms. People take it for granted, they really do. Americans take it for granted, but it's not guaranteed that we have this country. I mean, it could go to hell in a handbasket if that were to happen. We have tremendous checks and balances which give us 90% safety or 95% safety, but there's that 5%, that chance that something could go wrong. So, it depends. It ultimately comes down to every person. Like I said, like on January 6th, if Mike Pence had said, "Okay, President Trump, you're right. I'm gonna declare the votes of Georgia and Arizona invalid, and I'm gonna give the vote. I'm going to follow the 12th Amendment, and I'm going to declare Georgia and Arizona and Pennsylvania to be invalid, and now we're going to have the House." If he had said that, we would have had an absolute crisis, an absolute crisis. But he said in a very moving speech, he said, I've read history, I've read the Constitution, and there's no basis for the vice president to have the power to set aside votes. So, I give that guy tremendous credit for what he did that day. And so oftentimes, kind of the fate of the nation comes down to those kinds of things. So, you want to do, yes, back here.
I have more of a history question. So I know a lot of us know when the founders were framing the Constitution, they looked to like ancient philosophy or historical examples. So I was wondering, with the six powers in particular for the president that they set aside, were there other examples outside of maybe King George and the things they didn't like about him? Were there maybe examples of good leaders or bad leaders that helped shape those six particular powers for the executive?
Yeah, it's a great question, and I don't have a great answer. They certainly, as we talked about in class 1, the founders were all heavily read especially, certainly the classics, the Greeks and the Romans, but also especially the European philosophers of Montesquieu, Hume, Locke, and Rousseau. Those four in particular, and the works of those authors talked about how the separation of powers and the president be the one that the power to execute the law, and the veto power. I mean, I think Montesquieu talked about the veto power. So those powers were in those books. But there were really, when America was, the Constitution was radical. When we created this new country, there wasn't much example of it. The Netherlands had a little bit of an example, but there really wasn't much of an example of a government completely shaped, fresh and new by the Constitution, with the power resting with the people. So it really was a fairly radical idea, but some of the specifics were in in these treatises by these authors, that we were very fortunate that a lot of them had lived written in the 100 years before our Constitution. So we'll take maybe one last question, and then we're done. Yes, back here. Last question.
You mentioned the change to the electoral college.
Yes.
20%. I'm wondering where they came up with that number and where they traced the authority to do that in the Constitution, that process.
Right. So I think the number was just a raw compromise, right? Oh, so the question was the Electoral Count Act of 2022. So it was just it was just passed 2 years ago, and it was passed in response to the problems of January 6th. So the question was, where did they get the 20%? Everybody knew you wanted to increase it, right? You wanted to make it harder for Congress to question these votes, right? And we could get into the details. There's actually a safe harbor provision. They're really not supposed to question the votes if the states confirm their electoral vote before harbor. But they knew they wanted to increase it. I think some people wanted 50% or 33, but they compromised at 20. So there's no principle to that. It was just kind of raw politics. And then I think, the Constitution does give Congress, Article 2, Section 1 talks about the role of Congress in the Electoral College. So they felt that was probably enough of a constitutional basis. I don't believe it's been, I know it has not been successfully challenged. I think there may have been one lawsuit challenging I will tell you, almost every single law that gets passed there's at least one lawsuit challenging the law. And I think there was at least one lawsuit challenging that law, but it didn't go anywhere. So it has been held to be valid. Okay, well, that's it. Thank you very much. We'll see you next week. Yes.